Hello and welcome to the fourth in the series of dental negligence vlogs from the clinical negligence team at No5 Chambers. For those of you who haven't seen the first three vlogs, these are aimed at dental negligence lawyers and offer an invaluable insight from dental experts as to how lawyers can improve their chances of success and also reduce their costs when running a dental negligence case. Today we're going to be discussing the topic of Part 35 questions. My name is Louisa Sherlock and I'm going to be your host for today's vlog. I'm a barrister at No5 Chambers and a member of the clinical negligence and personal injury teams. I was a dentist for over a decade before becoming a barrister. Today I'm joined by Charlotte Robinson-Jones, Dr. Lucy Nichols and Dr. Elizabeth Tyler. Would you all like to briefly introduce yourselves, starting with Charlotte, please?
Hi, I'm a barrister at No5 Chambers in both the personal injury and clinical negligence teams. And I have experience of dental negligence cases, so advising on liability, causation, quantum, both in writing and in conference. And also I've been known to advise on quantum in terms of personal injury cases, so cases where someone suffered dental, facial injuries, that sort of thing, arising from a personal injury.
Thank you. Dr. Lucy Nichols.
Hi there. Yes, so I'm a general dentist working in a private practice. I qualified in 2000 and earlier in my career, I did some work in oral and maxillofacial surgery. I've since also done a master's degree in restorative cosmetic dentistry. And in the last few years, I've been doing dental negligence work. I currently do up to about 200 reports a year and I'm involved in writing reports for the General Dental Council and assisting in hearings as well.
Thank you. And Dr. Elizabeth Tyler.
Hello, I qualified in 2004. I'm a general dental practitioner working 3 days a week in mixed NHS and private practice. I was awarded fellowship in the Faculty of General Dental Practice in 2012. I was appointed as a clinical expert by the GDC in 2014. And also I carry out dental reviews for NHS England since 2017.
Thank you. I think it would be helpful, first of all, then, to have a look at the relevant civil procedure rule when considering written questions to experts. So here we see Civil Procedure Rule 35.6. 1. A party may put written questions about an expert's report, which must be proportionate to A, an expert instructed by another party, or B, a single joint expert appointed under Rule 35.7. 2. Written questions under paragraph 1 may be put once only, must be put within 28 days of service of the expert's report, and must be for the purpose only of clarification of the report, unless, in any case, the court gives permission or the other party agrees. 3. An expert's answers to questions put in accordance with paragraph 1 shall be treated as part of the expert's report. And 4. Where A, a party has put a written question to an expert instructed by another party, and B, the expert doesn't answer that question, the court may make one or both of the following orders in relation to the party who instructed the expert. 1, that the party may not rely on the evidence of that expert, or 2, that the party may not recover the fees and expenses of that expert from any other party. So this rule clearly sets out that written questions to experts must be proportionate and also for the purpose of clarification only. The rule also sets out that there can be serious consequences for a party if their expert does not answer a Part 35 question. There's also commentary provided. And it says that the meaning of clarification is not explained. However, it would seem that questions should not be used to require an expert to carry out new investigations to test, to expand significantly on his or her report, or to conduct a form of cross-examination by post, unless the court gives permission. There are 2 relevant cases which we're going to be talking about today. Those are set out here. So we have the case of Wilson and Al-Qaeda 2015 High Court case, and also the 2019 High Court case of Mustard and Flour and others. Charlotte, would you be happy, first of all, please, to summarise the case of Wilson?
Yes, thank you very much. So Wilson and Al-Qaeda was one of those unfortunate cases where the claimant had suffered a medical accident and had been left in a persistent vegetative state. And she relied on a medical report produced by a Dr. Badwan that was dated May 2014. And after it was served on the defendant essentially took issue because within that medical report, Dr. Badwan had said simply that the claimant could survive for many years in her current state. And the defendant wasn't happy with that as an answer. So in late December 2014, Part 35 questions were asked, or questions which the defendant said were for the purposes of clarification pursuant to Part 35. They were asked of Dr. Badwan. And Dr. Badwan replied in January 2015. And the relevant question for current purposes and the hearing was question 14, which said, on page 39 of your report, paragraph 6.3 with regards to prognosis, you say, with the present regime of care, Mrs. Al-Qaeda could survive for many years to come. 1, what is the anticipated life expectation of a woman in a vegetative state following traumatic brain injury at the age of 40? And then 2, how many years is it likely, in your opinion, Mrs. Al-Qaeda will survive? Shortly after the Part 35 answers were served, the defendant admitted liability and causation. So the claimant made an application to court for judgment and some directions. But there was also an issue regarding the Part 35 evidence in relation to life expectancy. And the matter went before Master Roberts, who gave various directions. And at paragraph 8 of the order, he said the defendant's application for clarification of Mr. Badwan's expert opinion as to life expectancy is dismissed. Now, between the parties, according to the judgment of His Honour Judge Gore on appeal from by the defendant from that order, there'd been a bit of correspondence between the defendant and the claimant, where the defendant, it was said in many letters, had said, essentially, we want to know what's going on with the situation and life expectancy. And the claimant's response was along the lines of, our position is that it's prejudicial to the claimant to be giving detailed life expectancy before all the appropriate factual evidence and information has been provided. So they said, we'll leave it up to the master to decide the issue. In the meantime, Mr. Badwan had provided a correspondence in March 2015, where he said, I'm sure you're aware of the difficulties in assessing life expectancy in the absence of any other medical evidence in particular. And then he says, in the absence of medical records for previous illnesses for the claimant, and further assessments regarding a tracheostomy she had, whether that will continue to be required, and also about the present feeding regimen, whether that's to be continued. And he said, providing an expectation of life expectancy at the time may not be accurate, and it may lead to erroneous assumptions that won't be in the claimant's interest. Should the court feel a preliminary indication is required, I'll be happy to abide by the court's decision. So Master Roberts considered the issue, and His Honour Judge Gore sets out some of the toing and froing between counsel and the master. And essentially the master seems to be saying, well, the expert needed medical records. And the way that it was worded is the master said, now, unless you have a letter from an expert saying, nonsense, you don't need any of that, and I've done mine, he said he's against it. So in other words, he was prepared to give some deference to the expert's opinion, Mr. Badwan's, because there was nothing from the defendant saying it was wrong. Now, His Honour Judge Gore, the first part of his judgment in substance starts at paragraph 8 of the judgment. It's quite a short case, so it's quite an easy one to read. But he starts off by saying, look, here are the rules as to what I can do when it comes to overturning a case management decision. So, for example, if there's an error of law or if the decision is perverse. He then went on to consider an issue that doesn't seem to have been argued in front of Master Roberts in any detail, and that's the Part 35.6, whether these questions are clarification or not. So the judgment sets out 35.6(2) that Louise has just referred to. And the judge pointed out that, well, the court hasn't given permission, the defendant hasn't, or the other party hasn't agreed. So the defendant can only ask questions that are for the purposes of clarification. And he said, well, yes, the defendant said these are for the purposes of clarification, but the judge said, well, in my judgment, the two questions are not clarifications. They're invitations to express an opinion that conspicuously the expert in question had not expressed in the report pursuant to which the questions were being raised. He then went on, he said, it's not clarification, but it's the expression of additional opinions. And he said that he agreed with submissions made on behalf of the claimant, that the claimant's solicitors were perfectly proper in saying to Dr. Badwan that he didn't have to answer the questions on the grounds they weren't legitimate Part 35 questions. The learned judge then considered the master's decision, and the reason he made his decision, and essentially the point that the expert, unless there was further evidence, was entitled to say, no, I'm not prepared to go any further, in my opinion. And essentially he said, well, that was an option open to the master. The master was perfectly entitled to decide that he was going to say the expert opinion will stand unless there is evidence to the contrary. And the learned judge made reference to the fact that this is a professional expressing an opinion as to why he can't give his opinion, in essence. So ultimately, the judge felt that he had to agree, and that the master's decision was one that he was perfectly entitled to make, and accordingly the appeal was dismissed. So the way I read it, there are a couple of take-home points from this case. Perhaps one is consider whether the questions are clarification. If you're an expert being asked the question, or if the questions are being asked of your expert, or indeed if you're asking them to another expert, are you actually asking for clarification here, or are you going beyond that and asking an expert for further opinion that for whatever reason they've not felt happy to deal with in their original report? The second point is there seems to be, on the part of this particular judge, deference given to the expert's opinion. So, well, if the expert says, I'm not prepared to provide an opinion because X, Y, Z, unless there is good evidence, seemingly from perhaps a defendant or the other side's expert saying, well, that's nonsense, as Master Roberts put it, the court's not really prepared to go behind that expert's report. And His Honour Judge Gore used a comparison with barristers. It seems to have discussed with the barristers involved whether they would feel comfortable. He said, essentially, it's a professional opinion. But I suspect perhaps what made a difference here is that in not answering the question, and given, Louisa, you referred to the provisions in the CPR that says there can be consequences if an expert doesn't answer a question, the expert did take the time to provide a justification as to why he felt he couldn't answer that particular question. So if there is an expert who says, I can't answer this, it's not good enough to say, I can't answer this. It's probably worth setting out in some detail the justifications that they're relying on as to why they don't feel able to answer.
Thank you, Charlotte. Looking now then at the case of Mustard and Flour and others, this was a 2019 case. This claim arose out of a road traffic accident. The claimant had a complex medical history, and she claimed that in the accident she sustained a subarachnoid brain hemorrhage and a diffuse axonal brain injury, such as to have left her with cognitive and other deficits. However, there were marked differences between the experts as to the claimant's presentation and the interpretation of her medical records, imaging, and history. In the application hearing in question, there were two principal applications made, in addition to several others. The first was in relation to covert recordings made by the claimant when being examined, which I don't need to go into in any detail. And the second was in relation to Part 35 questions to the defendant's experts. There were several experts in the case. These questions were extensive. There's a note saying that they filled 2 ring binders. And a combination of these questions and the question of the covert recordings prompted 6 of the defendant's experts to write to the court seeking directions. In essence, their complaint was that the questions would take a disproportionate amount of time to answer and that they amounted to cross-examination. When we look at the judgment, we see in paragraph 32, it says it said there that the rule, and that referring there to CPR 35.6, which I set out earlier, in its original form did not include the requirement that questions must be proportionate. So the mandatory requirement for proportionality was intended to address the practice that had arisen in some quarters of serving lengthy, complex sets of questions that were in reality a form of cross-examination. So counsel for the third defendant said that the questions were, among other things, wholly disproportionate and not solely for the purposes of clarification. The claimant counsel said that the expert evidence itself was lengthy, around 900 pages long, and therefore it was unsurprising that the questions were lengthy and complex. And also suggested that the experts could perhaps only respond to those questions that they felt were appropriate to answer, giving reasons as to why they were not answering other questions. The judge then decided to disallow the questions completely. He acknowledged that the questions were relevant and in part addressed areas of omission in the report, however decided that they were disproportionate, overwhelmingly not for the purposes of clarification, and that they amount to cross-examination. And what was said in the judgment of paragraph 36 was, and I quote, where there are omissions in the expert's report, these are, in this case, best addressed by supplementary reports and or by the process of joint meetings and joint statements. Such reports and joint statements are likely to render whole swathes of the questions redundant. As for the claimant's modifications to the questions, I agree with counsel for the third defendant that it is undesirable that the experts themselves should be forced to make a value judgment about the appropriateness or proportionality of a question or set of questions before choosing whether to answer. It is equally undesirable that they should have to formulate and express reasons why they choose not to answer. Questions should not be framed in a way that requires such judgments or explanations, which are the province of the lawyers, not the experts. To the extent that the commentary to CPR 35.6 suggests otherwise, I respectfully disagree. And it goes on to say, the judge goes on to say, I've considered whether I should embark on some sort of process of editing and refining the questions so as to bring them within the scope and the spirit of the rule, but I've decided not to do so. So in this case, because the questions just were so extensive, the judge decided to disallow them completely and didn't expect the experts to look at them and decide whether or not they should answer them or not. And I think that's interesting, isn't it? Because that follows on from what you said, Charlotte. And I wonder if perhaps in this case, it was just because there were so many questions that it would just have taken the experts so long to think about. It wasn't just one question. It would just been such a lengthy process.
Yes, it's proportionality. It's cross-examining. It's asking them to do an awful lot when it's expensive to be instructing experts to do that. The costs, no doubt, would be considerable on every side if they were to go through all those questions. And the judge said, try to make those value judgments.
Yes. So I think the take-home message from this is not to ask questions that amount to cross-examination, to really limit them and keep them really focused just to clarification and to make sure there's proportionality issue, as you say, as well. Dr. Lucy Nichols and Dr. Elizabeth Tyler, I wonder if you've had any experience of difficult Part 35 questions, and if so, if you could tell us about your experiences.
Well, I have to say, I haven't really had any of those types of questions. I found it very interesting listening to the two cases and considering about how that could affect me if it's something that arises in the future. But I'm fortunate that it's something that maybe doesn't come up so often with dental cases. I don't know, but it's not something that's really been an issue for me so far anyway.
So I would agree, certainly the questions that I've been asked so far have always been proportionate and relevant to my report. And I think for me, it highlights that really if I was unsure, I would go to my instructing solicitor to ask for clarification upon that.
Do you have any tips for lawyers when drafting Part 35 questions? Any way you think that they could improve their questions, for example?
Well, I think the two cases that you've discussed have really highlighted the main issues, which are keeping the questions proportionate and relevant and in keeping with what's in the report and clarifying what's already in the report rather than trying to take anything further.
Yes, and I would agree with that. And also I think as I believe has been discussed in previous blogs, the importance of keeping any instructions very specific I think that with dental cases, the notes that you can get can be reams and reams, often for multiple patients over many years. And so that's a lot of data and information to sift through. So the more specific the instructions, specifically in relation to timescale, the better.
Yes, and also I find that when you are questioned on a case, particularly if it's a complex case, it can take you a lot of time to kind of get your head back into the case, as it were. You know, you may have done your original report some time ago, so you may have really forgotten a lot of what the case is about, and the time that it takes you to really get back to where you were when you first wrote the report, it can be quite time consuming. And of course, if you're going to spend that time, then that is going to drive up cost as well. And I think as well that I would find it quite frustrating to deal with questions if it was in a way that I felt like it was being used in a way that was like cross-examination. That would be quite frustrating for me to be dealing with over email.
I agree. And in addition to taking time just to refresh your memory regarding a case, I think it's important to remember that expert witnesses are often practicing clinicians. And so in order to factor in enough time to do that and then to address the specific concerns and questions, I think it would be helpful if the instructing parties could allocate sufficient time for that.
Yes, I'd agree with that.
So how much time do you feel that you need really to get your head back into the case and to properly answer the questions?
I think that depending on the case, when I'm asked further questions on a case, sometimes it can take me 10 minutes if it's quite a simple case, but it could take an hour or even more than an hour, a couple of hours to really get back into the case again before I can even start considering the questions. And then in terms of timescales of when I'd be able to turn that around, again, as an expert, you're juggling your clinical practice and other reports that you're writing, all of which have deadlines as well. So, you're going to need an absolute minimum of 2 weeks and ideally 4 to 6 weeks.
I would agree with that. And also, I think it's important that the expert witness has sufficient time to go back to the primary source, so go back to the notes or the radiographs. And obviously, if there is a large bundle encompassing, many records over a long period of time, to go back to the original record or the original radiograph and really to get back into it can be quite time consuming.
Thank you. That's good to know. Charlotte, do you have anything to add?
The only other thought I had is some of the cases where I've seen Part 35 questions have been in the context of future losses. So sometimes you have the report where the expert says, well, actually, I think in terms of treatment, we might need, for example, an implant and then crown and bridge work, and the cost of this is X, Y, Z. It can make quite a difference to the value of the claim if it's not considered when those are going to need replacing. So actually, if you've got a youngish patient who's not only going to need an implant and crown and bridge work, but is going to need new ones at, say, 10, 15 years, whatever the expert opinion may be, the costs of that can add up quite quickly and it can make quite a significant difference. So if you are an expert preparing a report, that's perhaps one of the things I would suggest doing is try and make sure that you've made it really clear this is what's needed now and this is what isn't going to be needed at various points in the future. And then from a lawyer's point of view, it makes it an awful lot easier because you can then just plug in the figures into a schedule of loss and then present it to the defendant and say, well, the initial cost is X, but when you factor in the future losses as well, it can increase the value of a claim significantly.
Do you encounter questions on future loss? Lucy and Elizabeth, is that something that you come across?
I would say probably not, but that's because I routinely would include that in my reports anyway.
I think then the take-home messages are really to keep the questions really focused. Obviously, they have to be proportionate and for clarification only, and not not like cross-examination. And also need to give our experts enough time to answer the questions. So I suppose as soon as they come in from the other side, send them to you so that you have time to deal with them properly.
Yes.
Great. Well, thank you. Thank you so much, Charlotte, Lucy and Elizabeth, for joining me today to discuss the topic of Part 35 questions. For everyone who's been listening, thank you very much. And we hope to see you in the next vlog where we're going to be discussing oral cancer. Bye from all of us for now.
Thank you very much. Bye-bye.